Hello, everyone. Thanks for joining us today for another defined contribution focused webinar. My name is Steve Dufault. I'm a partner and head of corporate defined contribution here at Fiducient Advisors. I'm joined by Brian Lamb and Nate Ingraham from Thompson Hine to discuss recent trends in litigation affecting plan sponsors. For those not familiar with Fiducient Advisors, we are a national consulting firm focused on providing advice and counsel to sponsors of 401k, 403b, and other investment pools. I'm pleased to introduce Brian Lamb, who led Thompson Hine's business litigation practice for a decade. He represents companies and their directors and officers in complex business disputes, including ERISA litigation, securities, and shareholder litigation. Nate Ingraham is a managing associate in the Employee Benefits and Executive Compensation Group at Thompson Hine. Nate focuses on advising public and private companies on a range of employee benefits matters. He's represented defendants in a wide variety of class actions, challenging plan expenses, investment performance, and other matters. We're thrilled to have Brian and Nate join us today for this informative webinar. We have 45 minutes to dive into these important topics, and there's a lot of them, so let's move forward. I would like to remind you of our chat feature in the bottom of the screen, which you can directly send us questions, and we will answer as many as possible towards the end of our time today. With that, I'll turn it over to Brian and Nate.
Great. Thank you so much, Steve. It's a pleasure to be here. Here's a quick overview of today's agenda. We're going to talk about the big picture of what is up with ERISA litigation and why should you care about it, what's really going on there. Then we'll take a dive into the fee and performance litigation, which leads right into target date fund litigation. And we will wrap up with an overview of what's going on with the forfeiture litigation, sort of the latest craze here in ERISA litigation. So with that, next slide, I'll jump right in and start with ERISA and the role of litigation. Next slide. The big picture here is I'm guessing most of you participating today despise litigation, and unlike Nate and me, don't live for it and love it. You're looking for ways to avoid litigation. So our goal here today is to sort of tell you what's going on with the world of ERISA litigation. What are the plaintiffs' lawyers focused on? Where might their attention go in the future? And what can you do in the day-to-day operations and advisory functions of a plan to help keep out of the crosshairs? My main point I would like you to keep in mind is that when it comes to ERISA, litigation is just endemic. ERISA is drafted using a lot of general standards like prudent or reasonable or not excessive. These are particular drafting choices that are to be contrasted with, say, much of the Internal Revenue Code, which is more based on black and white rules as opposed to general standards. So an example, a black and white rule would be that you must stop your vehicle no less than 200 feet from a school bus. Okay, you have to maintain a 200 feet distance, and if you go 199 feet, you're going to get a ticket because you're 1 foot too close, and it's just that simple. That would be a black and white rule-based structure. A standard is something more like you must maintain a reasonably assured safe distance behind a school bus. Okay, well, what's that? Well, it depends. Is it nighttime or daytime? Is it raining? Is it icy out? Is it not icy out? And ERISA is full of these general standards where beauty is in the eye of the beholder. So it creates a playground for lawyers, and we love to fight about the meanings of these words, and then case law becomes very important. And what's really important is keeping on top of what the organized plaintiffs bar is doing. Going back 25 years, there was an organized plaintiffs bar focused on tobacco litigation. and then breast implants, and before that, it was asbestos litigation. Well, these organized plaintiffs' lawyers who have contingency fee-focused practices they follow the money. And today, the money is in America's retirement plans. Trillions of dollars are there being invested every day, and the plaintiffs' lawyers know it. So they come to the world of ERISA, where there's lots of room for debate about things, and there's lots of money at stake, and they constantly test out new theories. Fees and performance was a new thing 15 years ago. Actuarial assumptions over on the defined benefit side of things that just launched in 2018 and is still working its way through the courts. The latest craze in the retirement plan side is the use of forfeitures, which Nate's going to talk about here today. And if you care about the broader world, now these ERISA plaintiffs' lawyers are starting to take a look at health plans under ERISA, which are governed by the same fiduciary standards, but have not gotten a lot of attention from the plaintiffs' bar, and that is all changing right now. So that's like the big picture of what's going on here, and it's not going to change. There's a lot of money here, and ERISA is not changing, so the plaintiffs' lawyers are here to stay. Next slide, please. It helps to just have a sense of the litigation life cycle, even if you're not a litigator. It's important to know if a case is being decided at the motion to dismiss stage versus the motion for summary judgment stage versus being decided at trial. And early on at the motion to dismiss stage, the pleading standard is crucial. It's very favorable to the plaintiffs. It's very easy for a plaintiff to plead in their complaint the elements of a cause of action in a fee and performance case that will survive a motion to dismiss. I've been pining away for a Dudenhofer-like standard in the fee cases since 2018 when I first wrote a blog article about this. If you've been around a while, you know that employer stock used to be the favorite subject of the ERISA plaintiffs bar, and then the Dudenhofer case came out in 2014, and the Supreme Court changed the pleading standard and made it much more difficult for a plaintiff to plead a claim against a fiduciary for holding employer stock when the plan allowed that. If the employer stock plummets in value, the employer is still very well protected from a fiduciary perspective. I'm waiting and hoping that a standard like this comes along. I think the Supreme Court missed the opportunity a couple of years ago in the Northwestern case to set a standard like this, but they didn't. So what you see is most motions to dismiss are denied, sadly. So for the defense world, that means you're going to have the pain and expense of discovery and depositions and document production. And what we see is when you get to summary judgment at the end of discovery is defendants fare better. They end up winning a greater percentage of the time at the motion for summary judgment stage than they do at the motion to dismiss stage. Part of it's because there's a better record, and part of it is because the standard for granting summary judgment is a little more neutral than it is at the motion to dismiss stage. And then what we see in the ERISA cases is for the few defendants who have the gumption to take a case to trial, they almost always win. In most of the fee cases that go to trial, and there's a couple every year, the defendants have over 95% success rate. And a lot of that's because it's about process, and they can present their process to a judge. Here's what we did. Here's our minutes. Here's why we did this. Here's what we considered. Here's the questions we asked. Here's the experts we hired. And because ERISA is so heavily focused on process, courts, when they have the full record in front of them, tend to find in favor of the fiduciaries who can defend their process. Next slide, please. So let's dig into some of the litigation here. Next slide. The statutory framework, quick reminder, we're really in the excessive fee cases and the underperforming investment cases. We're really focused on the duties of prudence and the duty of loyalty. Most of the cases focus on the duty of prudence, okay? Care, skill, diligence. That is what most of these cases turn on. There's always a loyalty claim included. It's got the sharpest point from the plaintiff's perspective if there's proprietary funds involved, either proprietary to the sponsor or proprietary to a vendor that the sponsor does other kinds of business with, particularly in its corporate capacity. So you're facing prudence and loyalty claims, but mostly prudence claims. And what's really going on here is that ERISA allows most fiduciary breach claims to be brought on effectively a class-wide basis, even without a class being certified, because Section 502A2 allows one participant to bring claims seeking plan-wide remedies, like restore all losses suffered by the plan. And so this is what attracts the plaintiff's lawyers who work on a contingent fee arrangement. It's this magnifying effect of fiduciary breach claims in the ERISA context. We're not just talking about one participant's investments in a particular target date fund. We're talking about everybody's investments. So there's a exponential value to the plaintiff's lawyers if they win. Next slide, please, Nate.
Brian, before
So,
you go on,
yes, go ahead, Steve.
so a quick question about just from a protection standpoint, are there any trends towards more plan sponsors getting sued if they don't have a third party involved, like a third party expert, versus those that do?
Yes, for sure. Having a qualified expert that you've done your diligence on and that you engage with proactively, rather than blindly. It's still, whenever you engage a consultant or expert, it's incumbent on the fiduciary to ask good questions and to not just blindly follow advice. This is a super important concept. Judges do not like fiduciaries who just do what the experts tell them to do. They like fiduciaries who ask questions, and I like it when the minutes reflect questions were asked, a discussion ensued, the expert explained their rationale and the options and why they were recommending X. And that is just one of the best defenses to all these cases, is to be able to show you selected a good expert and then you interacted with them in a reasonable way. So these are the typical case theories in the fee and performance cases. There's a focus on record keeping fees, whether an RFP, when's the last time you did an RFP? What are you doing to benchmark? What are your experts telling you on the one side? And then when it comes to plan investments, the basic flavors we see are the lower cost share versus higher cost share debate, failing to use lower cost investments. Collective investment trusts are a big discussion now in litigation. The use of active versus index funds, is there a difference? Does the results justify the costs? And then, of course, the proprietary or affiliated funds. I'm going to throw a new one in here that sort of came up last week and didn't make it into these slides until the next page, I think. But now there was the first case I've seen where the plaintiff's counsel is going after the use of managed accounts as the QDIA for a plan. And is it the plaintiffs are questioning whether it makes sense for a plan to offer more expensive managed account services to serve as the QDIA for participants who didn't bother to select some other actively choose some other investments. So we're going to stick them in more expensive managed accounts as the QDIA. more to come on that. So, but this is an overview. We're either talking about expenses borne by the participants and should they have been lower, and we're talking about plan investments. Are they too expensive, and did they, of course, underperform over time? Next slide. New cases are being filed. People try to track these. It's a little imperfect because you have to categorize claims and such, but it does look like in 23 and 24, there's been a slight dip in the number of new cases filed. Nate and I have thought for a while that's because the plaintiffs' lawyers are having trouble digesting the cases that they filed once COVID started, and they just went on this tear. I will say the pace of settlements, class action settlements, is really picking up. I think they're working through the case log. Picture the anaconda who swallowed a pig and is now starting to digest it, and it's going to get hungry again. That's my theory, that we're going to see the pace pick up, because while certainly the bigger plans are the biggest targets, you're seeing a migration and an influx of smaller copycat plaintiffs firms coming in and filing cookie cutter complaints against smaller plans. And you're seeing, which has been unheard of before, class action settlements for under $500,000, for under $300,000. It's like the cost of giving notice to the class almost eats up the entire pool of funds generated here. You are just seeing smaller players go after smaller plans. So nobody is safe from these. Next slide, please. New theories. This is one. There is a virus-like effect of an evolutionary effect that the plaintiffs' lawyers have. They're super smart. They're super knowledgeable. They really dig in. They have close relationships with experts, and they're constantly looking for new waves of actions to bring. Right now, it's the forfeiture cases. We've had one ESG case go to trial, the American Airlines case. We'll probably do a webinar on that when we get a ruling someday soon here. I mentioned this latest trend of going after managed account services as the QDIA. It's just constantly changing because there's so much money and the standards are so general. There's just plenty of room for mischief. Next slide. All right, this is you, Nate.
Excellent. Hey, everyone. Great to be here with you this morning. So I want to pick up on, talk a little bit more about the pleading standard, what it takes to get past a motion to dismiss in one of these cases. Brian mentioned the litigation life cycle of one of these cases, and the motion to dismiss stage is a really critical juncture, because that's a chance to nip one of these cases in the bud before most of the costs are incurred in the case, which happens during discovery and in later phases. So, as Brian alluded to, that the Supreme Court in 2020 in Hughes v. Northwestern had an opportunity to promulgate a uniform pleading standard. And what the court elected to do instead was issue a narrow ruling and let the lower circuit courts of appeals develop case law as to the appropriate pleading standard in fee cases. And that's exactly what's occurred. So this slide, illustrates there's been a variety of rulings in different circuits. There's been some rulings favorable to plan sponsors, some rulings favorable to plaintiffs, and then some circuits, the Seventh Circuit and the Sixth Circuit, for example, depending on the issue presented to the court, will come out different ways on a motion to dismiss. And so we've looked at these decisions a bit deeper, and there are certainly some trends that we're continuing to see in terms of which claims are more susceptible to a motion to dismiss than others. And so it does continue to be the case that claims challenging the share classes of mutual funds used in plans, those are still harder to get dismissed at the motion to dismiss stage. The record-keeping fee cases, those generally are more of a mix. We've seen mixed results, but there have been a series of more plaintiff-friendly decisions coming out over the past few months, including one last week in the Third Circuit. And then lawsuits just challenging pure investment performance, especially if the allegations are with respect to short timeframes. The defense bar has had, and plans have had, some pretty big wins in the appellate courts over the past few years. And then in the BlackRock target date fund cases, which I'm going to briefly touch on in this presentation, there's also been some similar victories relying on that helpful precedent. So I want to talk a little bit more about these share class claims, because there's been some interesting case law developed. And so the way that one of the reasons that these cases have been hard to defeat at a motion to dismiss stage is because the way that they're set up, the plaintiffs will allege that there's a higher cost share class and a lower cost share class, and these investments are identical except for price. And so that can be, at least at the motion to dismiss stage, when you accept the allegations as true, that can be difficult to defeat. And so over the years, plans have presented arguments that relate to the net cost of the investments, and how higher share classes can have a lower net cost depending on how record-keeping fees are structured, for example. But courts have been wary about diving into that at the motion to dismiss stage generally. This Barrett Gold case, which was decided last year in the 10th Circuit, is an interesting case because in that case, the court took judicial notice of a trust agreement at the at the motion to dismiss stage, and that agreement indicated that a revenue credit was applied, and so the investment being challenged was actually a lower net cost than the investment that the plaintiffs would prefer. And so that's interesting precedent, because it's something that we hadn't really seen before, at least at the motion to dismiss stage. This United Surgical Partners case in the 5th Circuit, this was more of a plaintiff-friendly decision, but the court at least alluded to the fact that it may have considered documentary evidence at a motion to dismiss stage. I believe in this case it was whether the plan could show changes during the relevant period of switching from higher to lower share classes. And so I think the bottom line with these share class cases is that they continue to be difficult to defeat at a motion to dismiss, but courts are getting increasingly comfortable with these theories. And so it remains super critical for plans to have fee arrangements clearly documented, preferably in a way that is presentable to a court if need be at an early stage of a case. And I think that could be a successful way to nip one of these cases in the bud early on. Aside from these share class rulings, there's been a series of appellate decisions looking at record-keeping fees. And what's my takeaway in these decisions is that it illustrates how the plaintiffs' theories of liability have evolved. And so I remember back in 2020, when during early COVID, there was a wave of all these nearly identical fee class actions, and the common thread in the record-keeping claims was essentially that the fees were higher than average, and they'd cite to industry publications. Plans pushed back on that hard on their motions to dismiss, and definitely got some traction on that. And there's been good case law developed on that issue. But I guess to be expected, the plaintiff's bar has adjusted to those rulings. And now, so it's more typical in these complaints for plaintiffs to list the plan being challenged, and then they'll list a series of handpicked plans that have similar numbers of participants. And then the plaintiffs will allege record-keeping fees are fungible, as they typically do. And these recent rulings in the 5th Circuit and the 3rd Circuit have come to the conclusion that that type of theory, where you're mentioning other specific quote-unquote comparator plans, is sufficient to get past a motion to dismiss. So at least in the 5th and 3rd Circuits, it may be more difficult to withstand early challenges to record-keeping fees. But I want to take things back to, what Brian was saying about the litigation life cycle. The motion to dismiss stage is just the first stage of a case where you can challenge one of these cases. There's summary judgment and trial as well, where you have the opportunity to present more robust arguments, more developed arguments. And we have a lot of, both at summary judgment and at trial, we have several decisions over the past year where plan sponsors have prevailed. And so we really have, more than ever, a roadmap for how to defeat these cases, at least at trial. And so with that in mind, I want to hand back things over to Brian first and then Steve. And I think it would be great to get, both of your perspectives on litigation avoidance and some of the takeaways with these fee cases and how to develop, a robust record in the event that your plan is challenged in one of these lawsuits. So I'll start with you, Brian.
Thanks, Nate. So recognizing that these cases are not going away, your best defense is a defensible, well-documented fiduciary process. ERISA is all about process. Document your process. The plaintiff's lawyers will argue if there's no minutes, the meeting never happened. Or if the minutes don't reflect that a guest consultant joined the meeting and gave a presentation, then that's such a presentation never occurred. Now, judges don't usually buy that argument flat out, but you don't want to put yourself in a disadvantageous position. So have a good process, have it be a fulsome process, and document what you do. So having regular meetings is super important. Attendance at meetings, I cannot stress enough how much the plaintiff's lawyers scrutinize the minutes for the first line that shows who was in attendance and who was absent. And they tally it up, and that at the deposition of committee members will say, you missed 3/4 of the meetings last year, didn't you? Yeah. That doesn't look like the behavior of someone who is treating other people's money as if it was their own. So these little things like making sure attendance at meetings is viewed as important, making sure someone takes good minutes, documenting that questions were raised and discussion occurred. You don't have to say what the questions were, what the discussion was, but the fact that people talked about things and considered other options is what courts want to see. Relying on experts and consultants is indispensable these days. I mean, most committees are made up of people who themselves don't have all the expertise needed to stay on top of all the things a fiduciary encounters, from investments to record keeping to cyber stuff. It's like, so a fiduciary should delegate and appropriately rely on experts. And those experts should be having a good process around benchmarking. And the main thing I would say on the record keeping side is the plaintiff's lawyers will say thematically, this plan did not do enough to lower its fees every year. It did not do enough, didn't do RFPs, didn't do benchmarking, didn't hire an expert, never went back to the vendor, didn't bother to push back, didn't even ask for a reduction, didn't do a market check. That's what the plaintiffs are all about. And so if you can document we did all those things, then the dollar amount you end up paying is much more defensible. And you will need all this evidentiary support in the event you have to be deposed and try to win summary judgment, or heaven forbid, defend yourself at trial. Steve, what's your perspective on takeaways here?
Yeah. On the following slide, we talk a little bit about our governance deliverable, and I would agree on everything that you said. It's about process and what we can bring to the table and we do for our clients. This is our quarterly cadence, our fiduciary deliverable. So as a plan investment consultant, we do the investment review every quarter. Part of that investment review is looking at investment cost and benchmarking those fund fees relative to categories. So right there, we're nipping that each quarter. And then you can see the quarterly cadence here. In the first quarter, we do that fee benchmarking, Brian, that you talked about. So we're going to benchmark clients against similar clients, document the differences in service deliverables, right, that a client may have. And that's really important. You know, you talk a little bit about similar plans. Well, similar plans in size and number of participants and assets, right? But there are clients that have very significant, different needs from an administrative standpoint, maybe more frequent payrolls or more education communication needs. And those types of, administrative heavy type clients, they're going to pay more for record keeping. So we talk about that. We document why your fees may be where they are in terms of benchmarking. And if they do look high for some reason, then we'll recommend and go out and do an RFP or RFI to provide that fiduciary protection. So that's all built into that process. Further on in the year, the second quarter, we talk about investment menu design, looking at gaps and opportunities. And to Brian and Nate's point, things like looking at the intricate details of target date funds and stable value, for example, given that target date funds typically gather the vast majority of assets. Some plans, maybe 90% of assets are in target date funds. You want to go through that annual review of a deep dive into philosophy, process, the underlying components of target date, the fees, those types of things, and how they compare. And then committee makeup is really important. Brian just covered that, right? But it's having the right committee members involved. Not having too many committee members, but having enough that can have good debate and that can show up and can be good committee members and reflect that in the meeting minutes. That's critically important as well. Everything that we talked about so far is about procedural prudence, and that's what we bring to the table through this governance program. Try to hit many of those points and to help document those pieces.
I mean, as a litigator, Steve, I love this slide. I mean, I love the concept of a governance calendar. You're sort of superimposing some structure, and if you can get your clients to have some discipline around following this cadence and documenting it, I mean, it's Exhibit A in by the time we get to summary judgment or trial.
Great. Well, thanks, Brian, for that. So Nate, I think you're back. You're back, I think, at this point, right?
Yes. Thanks, Steve. So I'm going to just do a brief update on target date fund litigation. Steve mentioned a huge percentage of assets are concentrated in target date funds because they're often the QDIA in a plan. And this type of litigation is not new by any stretch. But since around 2019 or so, what we've seen lawsuits challenging target date funds being filed in waves where the plaintiffs' firms will pick a particular target date fund they're concerned about, and then they'll sue a bunch of different plan sponsors that offered that particular fund in their plan. And so probably over the past 4 or 5 years or so, the two most, in terms of number of case filings, I'd say the two most productive case streams are the cases challenging the Fidelity Freedom Funds, and then the cases challenging the BlackRock LifePath Index Funds. And so I want to spotlight the BlackRock cases just briefly, because many of those cases have worked their way through the courts at this point. And so I just want to bring everyone up to date on those. These were filed in the summer of 2022 by a single plaintiff's law firm. A dozen of them were filed, and the theory of these lawsuits was just that these BlackRock LifePath Index funds included in various plans underperformed relative to other leading target date fund series. And in the complaints, the plaintiffs took issue with underperformance over 3 or 5 year timeframes. The plaintiffs in these complaints readily admit that the funds are very low cost. There's no question about that. And so these are purely performance-driven complaints. When these cases were filed, because of that unique spin on the allegation, not concerned about cost, They generated a wave of concern in the industry, and I think rightfully so. And we've been continuing to look at them. And at this point, 2 years later, we can just report that in most of the cases that have been decided, courts have granted motions to dismiss in these cases, and courts have drawn on the principles developed in other fee litigation contexts. So the two basic rationales for dismissal of these cases has been first on the comparisons named in the complaint. So most, but not all jurisdictions, but a growing number of jurisdictions have held that to make to mount a challenge to an investment, you can't just say that this investment is bad in a vacuum. You have to provide more context, and you have to provide a meaningful comparator or a meaningful benchmark to that investment to show why it's imprudent or why it should pass through the motion to dismiss stage. And courts have determined that the comparisons made in these complaints between the BlackRock funds and other leading target date fund series that have different investment styles, different goals, different glide paths are not meaningful comparisons. And then on the underperformance basis, the courts have recognized that target date funds are meant to last, 2 and sometimes through retirement, and they're not investments to be critiqued on 3 and 5 year timeframes. And so that has been a solid win for plans at the motion to dismiss stage.
Hey, Nate,
yes.
could you go back to slide 17? No, it's 19. Steve's honeycomb slide. Yeah, there's a good question. Steve, did you see the question in the chat bar? Can you share more about the plan demographic review in Q3? It's interesting to me too. What is that all about? You're on mute. Oh.
Thanks. Yeah. Great question. So circling back to those questions, the plan demographic review, as plan fiduciaries, you should take a look at plan statistics such as participation rate, deferral rates, those types of things. And what we want to do, at least on an annual basis, is have the record keeper present those plan demographics. And as part of that also, that can also play into different plan design decisions, right? So if you're not getting participation that you want, maybe that leads into plan design enhancements such as automatic enrollment or auto deferral increase programs to help improve participant outcomes. So that's what we're talking about there, is making sure that the plan is acting in the way that you want it to, right? It's meeting the goals and objectives that you've set forth. And a lot of times those plan demographics will lead into plan design discussions, maybe non-Roth after tax, those types of things that we'll talk about as a follow-up.
Yeah, that is interesting. What I like about your calendar is it sort of, forces that discussion to happen in the third quarter, when if you didn't have that kind of discipline, maybe that's the kind of thing that keeps getting pushed out by the urgent, like, oh, something else is more important right now, so we'll talk about it. But when you have this, I really like the discipline of this calendar. To me, it's the epitome of a fiduciary discharging its duties, like to be this rigorous about the approach to handling other people's money.
Yeah, thanks, Brian. Thanks for that positive comment. We feel really good, and I'll tell you that it has been one of the significant value adds of the last 20 years that we've created for clients, and one of the reasons why clients hire us and retain us for a long period of time. Another question that came in with respect to the governance calendar was, what's the typical cadence for fee benchmarking? And I'll start here and turn it over to the team to also advise, but we do the fee benchmarking annually, and we think that's a best practice. And then when you talk about that next phase of conducting an RFI or pricing RFI or an RFP, it really depends on if you're able to prove or show that you've made an effort, right, to lower fees. So maybe you lowered fees in 2022, and maybe that pushes out an RFP or RFI for another couple of years, right? So I think if you can go back and show that you've had a track record of reducing your record-keeping fees over an extended period of time. That helps satisfy some of the need for RFP and RFI. But Brian, Nate, do you want to address that as well?
Yeah, that's a great approach. I'll just point out from a litigation perspective, the plaintiff's bar is trying to build a standard that an RFP should be conducted every 3 years, period. Of course, ERISA doesn't say that, right? It's neither a specific rule nor a general standard that you must conduct an RFP every 3 years. But you are seeing some courts who will say, if you did do this every 3 years, that definitely counts in your favor. And there's a question mark about if you don't do it every 3 years, how badly does that count against you? And that's just the real world dynamic of litigation. It's not in ERISA. So I would certainly, as a litigator, feel perfectly fine defending a 5-year, maybe even 6 years, if we had Steve's documentation of benchmarking in the meantime. And I think those two things do go together, but just be aware, plaintiffs' lawyers, it's such a yes/no thing. When's the last time you did an RFP? What? 4.5 years? What? It's crazy, Your Honor. That's what you get. So it may take a more nuanced answer, and you definitely want to have the documentation to back it up.
Hey, Brian, on that note, right, I mean, do you see a difference in what Fiducient Advisors calls an RFI, right? A less in-depth approach to fee benchmarking versus an RFP. Do you think that litigators, do they care whether it's an RFI or RFP, how in-depth that analysis was, or does it just need to have the comparative data from multiple record keepers based upon this plan-specific statistics?
We'll start with the mindset of the plaintiff's lawyer. Mm-hmm. They are going to minimize it and say, the question is, did you use your heft? Did you use the leverage, your buying power as a plan that holds all these assets to negotiate the lowest fee possible? I'm certainly fine as a litigator building a mosaic picture. We did this, plus this, plus this, plus this. And when you look at it all, that is what a prudent fiduciary would do. Plaintiffs' lawyers don't think that way, right? They're like, oh, you didn't do it in 4.5 years. Fail. That's their mindset. So I'm totally fine with building a defensible fiduciary process. So an RFI in the right circumstances is a great piece of the story. Doesn't have to be an RFP.
No, that's great. Thank you. I do want to get back to Nate to talk about that the target date fund litigation plays right into the governance, the governance piece of it, and monitoring and documenting why you chose what you chose, but also forfeitures. I don't know if we have a few minutes left to maybe talk about forfeitures, because that's a really hot topic in the industry today.
Yeah, absolutely. I think we should just jump right to that. And so on this forfeiture litigation, feel free to, all the attendees, peruse these slides. You can get them upon request. But just to give a short breakdown, around 11 class action lawsuits have been filed, all filed in California by just a few different plaintiffs' firms, challenging what plans use their forfeiture funds for. And so forfeitures occur when a participant terminates employment without being fully vested. So the non-vested portion goes back to the plan. And so the IRS has issued proposed regulations confirming these different ways in which plans can use forfeitures. But the plaintiff's theory in these cases is essentially that regardless of what the IRS says, under ERISA, the plans should have used the forfeitures to pay plan expenses in order to discharge their fiduciary responsibilities. So this is an untested, certainly a novel theory, and I would argue inconsistent with the IRS position on this. In terms of the Department of Labor, the DOL has not issued formal guidance on this issue, but we do know that the DOL has initiated enforcement actions related to forfeitures in different situations where the use of forfeitures was inconsistent with the plan language. In all of these cases, there's no dispute that the plans followed the forfeiture provisions in the plan, which gave the plan choices as to how to allocate the forfeitures. And so the bottom line is we're early on in this litigation. We have seen 2 motions to dismiss decided, and most of the others are pending. Courts have come out opposite ways on motions to dismiss. So on the Qualcomm case, which allowed a motion to dismiss, which denied the motion to dismiss, the court looked at the allegations and said, it essentially took the view that under the plaintiff's theory, administrative costs could have been lower. Let's let them work it out in discovery. And then on the more recent HP motion to dismiss, the court granted the motion to dismiss, and it found that, hey, look, unlike this other opinion, there's no duty for a plan sponsor to pay administrative costs of a plan. The court, characterized this theory that a plan has to use forfeitures in this way as a swing for the fences, and it said, I'm not having this, but it allowed the plaintiffs to amend the complaint, and the plaintiffs just filed their amended complaint last week. And the amended complaint, it looks similar to the theory, but has a slightly different flavor. And so that the new theory being asserted is a plan has choices about how to allocate forfeitures. And they said, if the plan is financially able to do so and isn't at risk of defaulting on its future contribution obligations, that plan should make the choice of using forfeitures to defray plan expenses. So we'll see how the court looks at that new spin on things. Bottom line is we're still in the early stages. There's a lot of unanswered questions in these litigation. And so we'll just have to see how things progress, and we'll certainly continue to monitor them. Great, and so lastly, my main recommendation with these forfeiture lawsuits is just look at the plan document and make sure that the current practices match the plan language and is consistent with the guidance that's been issued to date. I'd say that's my number one takeaway here. And it looks like we are 2 minutes over, so I'll end the substance there and let Steve take us home.
Yeah, well, thank you very much, Brian, Nate. A ton of great information here, right? I was a little worried at the beginning of the call because I felt a little bit scared. I thought you were going to walk us through how bad the world is. But I think at the end of the day, what we actually found out was there's a lot of bad stuff going on. But as plan fiduciaries, if you follow a prudent process, right, and document those decisions, you should be able to be defendable, right, in court. And depending on when the case, when you win the case, that's all up to how good those notes are and whether you have Brian and Nate on your side. Thank you so much for the great information today. I would urge everyone on the call to please feel free to reach out to any of the professionals at Thompson, Hine, or Fiducient if we can help you with your fiduciary matters. On that note, I wish you a great day, and thanks again to our experts from Thompson Hine. Have a great day. Bye-bye all.
Sure.